So a case challenging the NFA and its restrictions on SBRs is now in front of the Supreme Court and it's heading for conference. But the Trump DOJ continues to argue in favor of the NFA, and they argue that the Supreme Court should deny review to this case. So let's talk about what is happening in this critical challenge. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also double check to make sure YouTube has not unsubscribed you. And then also, I want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form is an amazing company. They're pro-freedom, pro-America. They support the Second Amendment and what we do here on the channel. So if you're interested, check them out using the link down below. And if you use my link and you order something $100 or more, you can get free shipping on that order. And they also have a money-back guarantee. As I mentioned in the intro, in this video, we're going to be talking about another important NFA/SBR challenge that is now currently in front of the Supreme Court and heading to conference in just a couple weeks. This case is called U.S. versus Robinson, and it's a challenge to the NFA and its restrictions on SBRs. This is a case that was ruled on by the 11th Circuit Court of Appeals, and in that ruling, the court found that the NFA does not violate the Second Amendment. They found that the NFA's SBR restrictions are constitutional, even in light of what the Supreme Court recently said in their Bruin decision. This has now prompted Mr. Robinson to seek Supreme Court review of this case, and the Trump DOJ recently filed their response to this case in another SBR case as well. And once again, they continue to argue that the NFA is constitutional and it does not violate the Second Amendment. This is now the second time in just a couple months that the Trump DOJ has argued in favor of the NFA, and they've actually argued against the Second Amendment. But now the plaintiffs in this case have responded, and like I said, this case is now heading to the Supreme Court conference in just a couple weeks. Now, the facts around this case are as follows. Essentially, on September 9th, 2022, law enforcement officers responded to a complaint that there was a suspicious car that was parked outside the front of this house in Florida. And when the officers arrived, they saw that Mr. Robinson was in the vehicle. He was asleep at the time. So they kind of knocked on the window, flashed some lights, in his face. He woke up, and then he attempted to drive away. They eventually stopped Mr. Robinson and they arrested him. And, after that, they searched the vehicle, and in the vehicle, they found a short-barreled rifle and then also a separate upper. They then searched the National Firearms Registration Transfer record, and it revealed that the rifle was not registered to Mr. Robinson, and so he was charged with violating the NFA. Now, after a bench trial, the district court found that Robinson was guilty of that violation, and later they imposed a sentence of 8 months probation, and then he also got 6 months of house arrest. Mr. Robinson then appealed his conviction up to the 11th Circuit Court of Appeals, and on review, the appellate court essentially found that he did, in fact, violate the NFA, and the NFA does not violate the Second Amendment, and it's still consistent with Bruin. Mr. Robinson also brought a tax argument against, the NFA, saying that it's an unconstitutional tax in violation of the 10th Amendment, but the 11th Circuit also rejected that tax argument. Well, now the decision is up for review in the Supreme Court, and in the petition, there were two questions that were presented to the court to consider, and those were whether the federal criminal punishment of the possession of an unregistered short-barreled rifle violates the Second Amendment, and also whether the federal criminal punishment of the possession of an unregistered SBR exceeds Congress's powers to tax under Article 1, Section 8, Clause 1 of the Constitution. Now, originally in this case, the government waived their right to respond to the petition in the Supreme Court, but then they were ordered to file a response by the Supreme Court. Now, in response, the Trump DOJ continues to argue that the NFA and its restrictions on SBRs does not violate the Second Amendment. And also in response, they asked for the Supreme Court to deny review to this case. In the brief, the Trump administration argues that there is no meaningful distinction or difference between SBRs, short-barreled rifles, and short-barreled shotguns, which were addressed in Miller. And they say Miller still stands as binding precedent on short-barreled shotguns, and it should also apply to short-barreled rifles. They also stated that Robinson's argument that these weapons are now in common use lacks evidence. They argue that short-barreled rifles remain not typically possessed for lawful purposes. They also lean heavily on saying that SBRs are primarily used by criminals. When addressing the tax argument, they state that the NFA is a special tax that is consistent with the nation's history and tradition. They argue there are 19th century laws which place taxes on dangerous and unusual weapons that were susceptible to criminal misuse. They point to taxes on weapons like dueling pistols, sword canes, Bowie knives, and other items as a justification for the current NFA taxation and registration process. They then go on once again to hide behind the argument that since there is no circuit split or no conflict between the lower courts on the whole NFA constitutionality under the Second Amendment, that essentially right now the Supreme Court should deny review to this case. They argue that every circuit court to consider this issue before and even after Bruin have upheld the NFA's SBR restrictions and all the other provisions, and therefore until there is a conflict in the lower courts, the Supreme Court should simply punt this case once again. But now Mr. Robinson also filed his reply pushing back against what the Trump DOJ said. And, he is saying that the Supreme Court here should not deny review to his case. In the reply brief of Mr. Robinson, he argues that the NFA does violate the Second Amendment and also is against Congress's taxing powers. Robinson contends that the U.S. versus Miller case actually supports his position, not the government's position, because it recognized protection for arms in common use for lawful purposes, which includes short-barreled rifles. He points out that SBRs are standard issue military weapons and far more common than short-barreled shotguns, and have expanded also in civilian use and ownership since 2011. The ownership of SBRs has exploded. He also argues that the government's reliance on scattered 19th century knife and pistol laws essentially fails to show that there is a real historical tradition of regulating the size and type of firearms that are in question in this case. When it came to the taxing power issue, Mr. Robinson says that the precedent does not save the NFA because prior cases only upheld a dealer tax, not the intrusive regulatory scheme imposed on individual gun owners like what happens with the NFA. He lists the extensive burdens placed on individuals like fingerprinting, registration, ATF permission to travel, and severe criminal penalties as proof that the NFA's $200 tax actually functions as a penalty, not just simply a legitimate tax. He goes on to argue that the NFA was designed to actually suppress conduct, not simply to raise revenue and taxes. And he says that if that was the case, if it was simply just for the collection of taxes, well then why do you have the DOJ enforcing this instead of the IRS? And that's why it shows that this is simply not just a tax scheme. It's not something just so, simple and harmless. There are serious criminal penalties attached to this which are enforced by the DOJ. He closes by urging the Supreme Court to grant review and strike down the NFA's application to SBRs as unconstitutional, both under the Second Amendment and also the taxing clause. So this is now the second NFA SBR Second Amendment challenge that has been sent to the Supreme Court. And both of these SBR cases, the Robinson case and also the other case, which is called Rush, are heading to the Supreme Court conference on December 12th. This is also the second time that the Trump administration has argued in favor of the NFA and claimed that it does not violate the Second Amendment. So once again, the Trump administration is arguing against the Second Amendment. They're arguing in favor of the NFA, and they're actively pushing the Supreme Court to deny review to this case. This will now head to Supreme Court conference in just a couple weeks, and then we're going to see how does the Supreme Court intend to handle this case. Are they simply going to punt this case like the Trump administration wants, or are they going to take this on like the petitioners ask? So as this develops, as we get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of the two videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.